Hello, everyone. So we have a small class today because we've got a few people out on FTX weekend, but we also have a short class. We just have a few slides to cover. So quick reminder, our quiz is today starting at noon, and you have until noon tomorrow to take it, with the exception of Tristan and Hunter. Hunter, I see you. And Tristan sent me an email. He's doing FTX stuff. So Hunter and Tristan will not take your quiz today, and you guys will play live on Monday. Do we have any questions about that stuff? No. Okay. So just to let you guys know what's coming up next week. So we have 2 paper workshops and then a guest lecture. We're going to have either 1 or 2 officers from Charleston Police Department come give a guest lecture about the stuff that we learned this week. But they're going to talk about how they do this stuff in practice, the changes that they have to make whenever decisions come down, and be able to answer any questions that you guys have about search and seizure and things like that. All right, so let me share the lecture and we will get started. Sorry, my computer's running a little slow today. Okay. Let's just get to where we were. All right, so the last thing we talked about on Wednesday were the public safety exceptions to search and seizure. So these are the things that do not require probable cause or a warrant. So if they are searching for a weapon, if you are in an airport, if you're a bus passenger, it just requires consent. Border search, basically anything goes. In school searches, they have the authority to search all property in the school and near the school. But as we saw with Safford versus Redding, just because they do that does not mean that they cannot be sued if they step over the line like they did in this instance. All right, so let's start by talking about deadly force. So public safety is the focus of the slide. The police reason that occasionally deadly force is necessary for public safety. The fleeing suspect is potentially a huge risk to the community, and it's those types of people that participate in reckless behavior that can often turn deadly. So that's basically the rationale behind why the police are able to use deadly force. It's kind of the idea that saving the or taking out the one to save the many. That's kind of the rationale that they use here. So some police departments allow for the use of deadly force for a fleeing suspect, and some departments didn't use to require a felony. So it's up to each department to create their policy on when they can use deadly force. But the Supreme Court gave them a couple of guidelines in Tennessee versus Garner. This case wasn't until 1985. So prior to 1985, police departments could kind of do whatever they wanted. Again, they still make their own policies, but the Supreme Court has given them some requirements for this. So let's talk about what happened with Tennessee versus Garner. So around 11 p.m., 2 officers were called to the scene of a burglary. And when they got there, they found a man running across the backyard. The cops saw that he was unarmed and he told him to halt. The guy ignored him and he tried to climb a fence, and the cop shot him in the back of the head and he died. This kid, actually, they only found $10 in a woman's purse on him. And it was this case that went all the way to the Supreme Court. And so the Supreme Court ruled what is not acceptable for the use of deadly force. So the problem was, at that time, they were allowed to do that because that was their policy, and the Supreme Court had not stepped in to say that it was not okay. So in Tennessee versus Garner, the Supreme Court ruled that a police officer may only use deadly force to prevent the escape of a fleeing suspect if that person poses a significant threat of death or serious physical injury to the officers or to others. This is what they refer to as the clear and present danger policy. Basically, the officer has to be able to say that there was clear and present danger, which is why they use deadly force. Since Garner did not pose a clear and present danger, he did not pose a significant threat, the officer should not have used deadly force. The reason he did not pose a clear and present danger was because the officer saw that he was unarmed, so there was no reason for them to be using deadly force. So we've made a lot of changes since Tennessee versus Garner in terms of the weapons that officers are able to use. They now have a lot of non-lethal weapons that they can use in their disposal. They have all kinds of chemical sprays, so the OC sprays, they have tasers, they have, I mean, they had their baton back then, but now they have other options. If they have not seen clear and present danger, they can try to stop a suspect using their hands, using the OC spray, or using a taser before they resort to deadly force. But that is basically the threshold that the Supreme Court set, and it's still up to each police department to create their own deadly force policy, but clear and present danger has to be a part of it. Questions about deadly force? There's a lot of stuff on this. We're just giving the basics because this is an intro class. If you go to law school or to the police academy, you will learn the specifics of their deadly force policy for that state. And what we can do is have the officers next week speak a little bit about the deadly force policy at the Charleston Police Department. All right, let's talk about what they can and can't do during an interrogation. So the U.S. Supreme Court, the first thing that they had to do was define an interrogation. So they defined an interrogation as any behavior by the police that the police should know is reasonably likely to elicit an incriminating response from the suspect. So basically any form of questioning, the police should realize that that is considered an interrogation. And the interrogation of suspects, like any other any other area of police activity, is the subject to constitutional limits as interpreted by the courts. So the first limit that we're going to talk about is physical punishment and pain when interrogating a suspect. So the first significant case we're going to talk about is Brown versus Mississippi, and this was way back in 1934. What happened here was pretty awful. A white store owner was killed during a robbery, and a posse led by the sheriff went to the home of an African-American man rumored to have been one of the perpetrators. They dragged him from his home and put a rope around his neck, hoisted him into a tree, which they did repeatedly trying to get a confession out of him. Then they rounded up the rest of the people that they thought were suspects and beat them with belt buckles until they confessed. So, as you might imagine, the Supreme Court overturned all three of those convictions because of physical punishment and pain. So the Supreme Court ruled in Brown versus Mississippi, you are not able to use physical punishment and pain during an interrogation period. All right. So Ashcraft versus Tennessee, they proved that an interrogation doesn't have to use physical abuse for it to constitute physical pain and punishment. So Mr. Ashcraft was accused of murdering his wife and was interrogated from Saturday night until Monday morning, when he finally made a statement that implicated himself in the murder. So during this period of time, from Saturday night until Monday morning, they shined a bright light directly in his eyes. They refused to let him use the restroom, and they refused to give him any food and water. So obviously, after this man made some sort of statement, they went ahead and arrested him and moved forward with it. And this case made its way all the way to the Supreme Court, who ruled that even though the cops didn't lynch him and beat him with belt buckles, the fact that they held him from Saturday night until Monday morning, shining a light in his eyes, refusing to let him use the restroom or have any sufficient food and water, was enough to hit the limit of physical punishment and pain. So they overturned the conviction based on the statement that this man made after he had undergone all of that. So let's talk about psychological manipulation. The Supreme Court has also ruled about that during an interrogation. So, similarly, like they can't use physical pain and punishment, they cannot involve sophisticated trickery designed to get a confession. However, lying to a suspect is perfectly legal, and you see that all the time. They'll round up 3 or 4 suspects, put them in separate rooms, and then say the other one ratted on the other one to get them all to confess. That is perfectly legal. But let me explain what crosses the line. So, what happened in Lyra versus Deno was they sent a psychologist in to speak to the suspect, and they were hoping that the psychologist would use psychological manipulation to get this suspect to confess. When the suspect did confess, this person was convicted, and it's made its way all the way to the Supreme Court. And the Supreme Court said that since they sent a psychologist in who was trained and able to use their skills in a deceptive manner, more specifically, they were trained to get the information through the veil of confidentiality. So, the biggest problem the Supreme Court had here, when you speak to a psychologist, your conversations are supposed to be protected. So most people think when you talk to a psychologist or any sort of therapist that the conversations aren't going to go beyond that. So when they sent a psychologist in, this person thought that they were speaking confidentially to a psychologist, and that was why the Supreme Court overturned this case. It was the veil of confidentiality. The police sent this person in hoping that they would get a confession and tell them what this person said. Generally, when they send a psychologist in during an interrogation, they are either not supposed to record it, or anything that is said is not supposed to be used against this person. It's kind of the same thing if you confess your crime to a priest. They're not supposed to tell the cops what you said because of that confidentiality.
So like you use the term like supposed to. Is this like so like if they did tell them, like would it be a breach of like their rights, or would it?
So they can send their like their own shrink in there to do a psychological assessment, and that is separate, right? That's completely separate. The person knows that what they say to this person is going to be used against them, but it's when they send a psychologist in kind of posing as a cop, and or saying actually he wasn't posing as a cop. He came in and said, I'm a psychologist, I'm here to talk to you, but he was working for the police, and they didn't let him know it was like a psych exam and it could be used against him. He just thought he was getting help from a psychologist. So that's why I don't want to use hard and fast terms like that, because the details really make a difference. But if you are using it, basically they were using that to psychologically manipulate this person to confess, and this person was not under the impression that what they were saying was going to be used against them in a court of law. Now, when they do order a psych eval, usually it's a judge that can order that sometimes to see if a person is fit to go up for trial. Then they know whatever they say can be used against them. Does that make sense? All right. So I want to clarify one thing that your book says. It says that confessions gained after placing an officer in a cell posing as another inmate are admissible. This is true, but you have to be very careful how you do it, because it can you can kind of put it under physical punishment and pain. So basically, if you put an officer in a cell with this other person and they're trying to get a confession out of them, and they're sort of threatening, like, if you don't tell me what's going on, the other inmates and I are going to beat up on you, that's when it kind of crosses the line towards physical punishment and pain. So if that's when it becomes a coerced confession, and you are not able to use that in a court of law. So you can do this. You just have to be very careful how you do it so that you're not coercing a confession, and you have to make sure it's not hearsay. So, for instance, if you are undercover as an officer in a cell, but you hear from another inmate that the guy you're trying to get confess to him, that's hearsay. So it's possible to do, but you have to be very careful how you do it. Otherwise, it's going to be thrown out in a court of law. All right. let's talk about the right to an attorney. So most people think your Miranda rights or the Miranda case is where the right to an attorney came from, but that's not actually the case. The right to an attorney was developed 2 years prior to that in a case of Escobedo versus Illinois. So in this case, this was 1964. The Supreme Court ruled that you have the right to legal counsel present during police interrogations. That's the first time the right was actually incorporated. Miranda just says, we're going to talk about this in the next slide. Miranda just says they have to tell you that you have that right, but it was 2 years prior in the case of Escobedo versus Illinois that the Supreme Court said you have the right to an attorney while you're being interrogated by the police. So there are thousands of cases. There's all kinds of case law noting or specifically outlining what constitutes asking for an attorney. So just keep in mind, every time I give you a case, just know that there are hundreds more, just narrowing down exactly what this means. So Escobedo versus Illinois says you have the right to an attorney while you're being interrogated, but there are hundreds of other cases outlining specifically how you ask for an attorney if that constitutes that right. So there's also case law determining what can happen between when you ask for an attorney and when that attorney arrives. Literally every single process of the criminal justice system has been litigated in hundreds of different ways. So let's talk a little bit about asking for an attorney. So Michigan versus Jackson. So this found that if a suspect has invoked the right to an attorney at an arraignment or an earlier proceeding, the police cannot initiate an interrogation without that attorney present. So basically, the Supreme Court has ruled that if you ask for an attorney, they cannot interrogate you until that attorney arrives. All interrogations have to stop. So there's also a Supreme Court case about how much time can go by between when you ask for an attorney and when that sort of request expires. So you don't have to know this case. I'm just going to explain it to you. This was actually in 2010, the case of Maryland versus Schatzer. Mr. Schatzer was serving time for child abuse, and the police asked him a question while he was incarcerated, and he asked for a lawyer. So the interview stopped. 2 years later, they came back and asked him the same question, and he made an incriminating statement. And then he said, oh, wait, remember I had asked for an attorney 2 years ago. You can't interrogate me. The Supreme Court ruled that the 2-year break was too long, and they said it has to be 14 days. So if you ask for an attorney and 15 days go by and they ask you another question without your attorney, you have to request that attorney again, because if you make an incriminating statement, it will be upheld in court. So the Supreme Court has ruled that there's 14 days between when you request an attorney and when they can ask you a question again. If your attorney is not around, that initial request for an attorney will not cover you. It's only 14 days. So if you're being interrogated and you ask for an attorney and 15 days later, they try to interrogate you again, you ask for an attorney again. All right, let's talk about Miranda rights. So in the area of suspect rights, no case is as famous as that of Miranda versus Arizona. This was 1966. So again, anytime you see something in the 60s, assume it's a fairly liberal case in terms of offender rights, because that was during the Warren Court. So in the area of suspect rights, no case is as famous as the Miranda case, which established the well-known Miranda warning. So many people regard the Miranda warning as the centerpiece of the Warren Court due process rulings. People were really upset by this because of what happened with this case. So even though everybody loves the Miranda warnings right now, wait till you hear what Mr. Miranda did. So Ernesto Miranda was arrested in Phoenix, Arizona, and was accused of having kidnapped and raped a woman. At police headquarters, he was identified by the victim, and after being interrogated for 2 hours, Mr. Miranda signed a confession. On appeal, so his attorney appealed this conviction. So the problem mainly was Mr. Miranda didn't speak English very well, and they didn't give him a translator. So I think that is what set this off. So on appeal, the Supreme Court rendered what some regard as the most far-reaching opinion to have affected the criminal justice system in the last half a century. So the court ruled that Miranda's conviction was unconstitutional because the entire aura and atmosphere of police interrogation without notification of rights and the offer of assistance of counsel tend to subjugate the individual to the will of the examiner. So the problem that they had was that they didn't tell Mr. Miranda his rights and they didn't offer him an attorney. So they overturned Mr. Miranda's conviction and at the same time took the time to say, anytime you are arresting a suspect, you have to tell them their rights. So the well-known Miranda rights, which we all know, the police now have to tell you, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer, and you have that right to have one present while you're being interrogated. If you cannot afford a lawyer, one will be appointed to you at no cost. And if you start answering questions without a lawyer, you have the right to stop at any time and request a lawyer. So now, to ensure that proper advice is given to suspects at the time of their arrest, the now famous Miranda rights are read before any questioning begins. And once subjects have become informed of their rights, they are commonly asked to sign a paper. So every police department is a little bit different about how they enforce this and even how they say it. So sometimes they say it slightly differently. You may have heard it, like if you ever watch Law and Order, sometimes it's said slightly differently from this. Each police department can create their policy as long as they say these things, but they can say them slightly differently. But now a lot of times police officers will have you sign a paper saying that you have been read your Miranda rights and that you understand your Miranda rights. And some departments make you initial next to each right to ensure that you're not going to come back and say, oh, but I didn't hear that one. I didn't understand that one. So the heinous nature of the crime that Mr. Miranda committed and the fact that the victim identified him in a lineup, that is why our nation was so upset that this case was overturned. It wound up becoming a very, very famous case, and this is something that most average person knows, the Miranda warning. But the Miranda warning was almost overturned in 1999. So let me tell you a little story about adults acting like children. Oftentimes, the legislative branch does not like it when the Supreme Court steps in and strikes a law down. The legislative branch sees that as their job, right? They're the ones that pass laws, but the Supreme Court has the authority to have judicial review over laws. If they see a law that they think is not constitutional, they have the power to strike a law down. They also have the power to create laws just like this. And occasionally when they do that, the legislative branch gets its nose out of joint, which is exactly what happened here. They did not want the judicial branch creating law like this. And because of the heinous nature of the case, the public was really upset about this. So what Congress did was, so 2 years after this, so this was 1968, Congress passed an almost forgotten federal statute with the intent of overturning Miranda. So basically, they quietly passed a law that said that a confession shall be admissible in evidence if it's voluntarily given. And they intentionally left out the Miranda warning. What they were hoping was that this would come up in front of a different face of Supreme Court justices 20 or 30 years later, who would then uphold that law, which would overturn Miranda versus Arizona. So sometimes you see the legislative branch do something really sneaky like this. If the Supreme Court passes a law that the general public and the legislative branch does not agree with, sometimes they will attempt to write a law and hope that it takes a while, decades for it to get in front of the Supreme Court, where there are different Supreme Court justices that might agree with that, and then they have the power to overturn that. We actually see that happening now with abortion. A lot of states are passing abortion laws, hoping that it will make it up to the Supreme Court, who's a lot more to the right and more conservative now. They're hoping that the Supreme Court will uphold that law, which would overturn Roe versus Wade. So what they did here is not new. They do this a lot. So Dickerson versus US. So like I said, 1968, Congress passed that law. And in 1999, this case finally made its way up to the Supreme Court. So Mr. Dickerson was arrested for bank robbery for using a firearm during a crime of violence. Both of those are federal crimes, and this was a federal statute. He moved to suppress the statements, or his attorney moved to suppress the statements that he made to the FBI because he did not receive his Miranda warning before he spoke to the FBI. So this is another reason it took 30 years to get all the way up to the Supreme Court, because people are so used to giving the Miranda warning that it's rarely not given. They know it's going to be thrown out in court. So finally, 30 something years later, this case, they had managed to not give this man a Miranda warning. He made an incriminating statement. It made its way all the way to the Supreme Court, and the Supreme Court upheld Miranda versus Arizona. So the Supreme Court ruled that the Miranda right was to be upheld. The Miranda warning was to be read to all criminal suspects, and they struck down that federal statute that they passed in 1968 with the explicit intent of overturning Miranda versus Arizona. So the last case we're going to talk about is Henri Galt. And this is the case that defined juvenile rights during an interrogation and arrest. This case basically said when you're dealing with a juvenile, you also have to give them the Miranda warning as well. Anytime you see Henri, that just means that somebody else brought the case for you. So in this instance, Gerald Galt, his father brought the case for him because he was a juvenile. So if you see Henri something, that just means that somebody else had to bring the case for this person, either because they're a juvenile or they're deceased or whatever reason. All right. Do we have any questions about the Miranda rights? No questions? Okay. So your quiz is going to be available starting in 30 minutes. Hunter, don't forget not to take your quiz. Yep, good. I see your thumbs up. So Hunter and Tristan will be playing live on Monday morning. So just a quick overview of what we're doing moving forward with the rest of the week, next week. So part of your research and writing assignments is to write a short 2-page research paper. So over the weekend, just be thinking of any sort of criminal justice topic that interests you. What we're going to be doing on Monday and Wednesday. On Monday, we're going to be looking for articles you have to have 2 articles for this research paper. So we're going to have a little workshop. I'm going to show you how to use the library website in a very effective way, how to read research articles. A lot of times students shy away from scholarly articles, 1, because they're very long, and 2, because they are often using very complex statistical terms. I'm going to show you how to read a research article and what parts of it that you can avoid, so that it's a little bit easier for you to read them. I'm also going to show you how to find them, how to save them. There are a lot of different ways on the library website that can be very confusing for students, including the interlibrary loan, full text finder versus PDF full text. We'll go through all of that. And then on Wednesday, what I'm going to do is show you how to start building an outline in a very organized manner to make research paper writing extremely easy. This is probably not the first, nor will it be the last time you will be asked to write a research paper by a professor. So basically, I'm going to give you professor and grad student secrets about how to do this really easily. All right. So over the weekend, just be thinking of anything, any sort of criminal justice related topic. And even if it's slightly outside the scope of the criminal justice system, if it's interesting to you, let me know, and I'll see if I can find a way to make it fit with the criminal justice system, so that you can have a little topic for this little paper that you're going to write. Okay. Questions?
I have a question. Is juvenile delinquency a criminal justice topic?
Yes, it is. It absolutely is. So what we can do on Monday, we can use that search term. And so that is a very wide abstract term. So what we'll probably want to do is narrow it down. And one of the ways that I like to teach students to do that is we'll just type that in, and then we can start going through the topics, or we can start going through the titles. And basically, if you see a title about juvenile delinquency that interests you, that can be one section of your paper. The second title can be a second section of the paper, and then we'll talk about how to link those together on Wednesday. All right. Other questions? Does anybody want to throw a topic at me? I just sprung this on you, so if you don't know.
So I got a question. Well, my roommate actually had a question. He asked, he was like, what's like the youngest that someone can be arrested? Because I remember like hearing a story that like a kid, or like an 8-year-old, I think it was, like killed his mom and he was arrested. So what do you think the youngest would be?
So that's going to depend on the state, but if you murder someone, regardless of your age, they're going to arrest you. What they do with you is the difference. So for someone that young, they're probably not going to sentence you to juvenile detention. They might send you to a psychiatrist to be watched very, very closely, and you might be under some sort of probation. Really, it's going to depend on the state. And depend on the crime that you committed and your age. But if you murder someone, they're going to be all over your ass for sure.
Yes, ma'am.
Other questions?
Speaking of topics, with a case, like, because I was thinking like a Escobar case, for example. Like, would that be technically a topic that we
Sorry, you're breaking up a little bit. The Escobedo case or Pablo Escobar? I couldn't tell what you said.
Pablo Escobar.
Okay. Yeah, you want to write about Pablo Escobar specifically?
Yes, ma'am.
Yeah. So we can definitely do that. Basically, what we're going to see is what's available on the library website so it's not just like a middle school book report. We're going to make it a little bit more empirical. So we'll see what's available online and we'll go from there. But that's a totally feasible topic. But this is usually how it starts, is just a very general idea. And then we'll look at the articles that are available, and whatever interests you, that'll be the direction that we take this paper. Other ideas? All right. Well, if there's nothing else, enjoy this horribly dreary Friday. And I will see you guys on Monday. Don't forget to take your quiz. See you guys then.